You have the lineup as Kagan, Sotomayor, and Breyer, who are defenders of the constitutional right to pre-viability abortion, being established first in 1972 or 1973 in Roe versus Wade and reaffirmed in 1992 by Casey as a constitutional right established by a reading of the right of privacy and the other rights that are expressed in the Constitution, but these are implied rights that are given usually just as much enforcement and validity as any other right, even though it's not in the literal text. That's where those three line up. Then you've got Thomas, who doesn't believe there's a constitutional right embedded in the Constitution to abortion pre-viability at all. You have Alito, who doesn't believe that either. You have Kavanaugh, who is siding quickly with Alito and Thomas on this issue and believes, and said this in questioning, which was really pseudo-questioning, really statements of what his position was, staking out his position, that the Constitution is neutral on abortion. I guess it means that the Constitution didn't have the word abortion in it, and therefore we should be neither pro-abortion or against abortion. We should let the states decide, which means 26 states within a year of a decision allowing it will ban abortion outright. But he's okay with that. And then you have the last two, which is Amy Coney Barrett, the mother of seven, Catholic law professor, who in her own questioning said, why do we even need abortion? Because adoption laws and safe haven laws are pretty well established. That's not a good sign for where she sits.
The safe haven law part was even extra kind of handmade.
Drop them off at the firehouse. That's okay.
Yeah. Why would you need it? What you should do is, if you're a victim of, rape or incest, what you can do is carry it through term and then abandon it.
Right.
Why? And she was asking the government and others, why didn't you address this argument? We have safe haven law.
So we know where she's going to end up. And so what is the fight, the ideological fight that is now going to happen in conference among the law clerks and among opinions that will be circulated between the right and the left between now and June or July? The ideological battle is between Justice Roberts, who wants to find, based on his questioning and his past rulings and his approach, he wants to find and maintain a constitutional right to an abortion, but he wants to limit it back to at least the 15 weeks that's in the Mississippi statute.
Right, the Mississippi statute bans abortions after 15 weeks.
Right, and the other one is 24 weeks.
And so what you're saying here, which is what's kind of shocking about this oral argument, is that probably the best result that could come from a pro-choice perspective is just that the Mississippi ban is upheld and that the Supreme Court doesn't go further and just completely claim and assert that the right to an abortion doesn't exist.
You're right. The best case scenario is that Roberts gets Gorsuch over to his side, which is going to be a heavy lift. And then in combination with Breyer, Kagan, and Sotomayor, they both reaffirm the constitutional right to pre-viability abortion, while at the same time removing the viability line that was established by Casey and Roe v. Wade, which is 24 weeks. So 24 weeks get rolled to 15 weeks, but the constitutional right is maintained. That is one outcome. If Roberts is not successful in getting Gorsuch over to his side, the constitutional right to an abortion will be eliminated. It'll be the first right that has been eliminated in the last 150 years.